Again, we said that we're going to do a series of adjustment of status videos, and this is part 2. We're going to talk about denial of PD request again, and we're going to talk about why it was denied and how to go about it. As you know it, my name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share. Like it, don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into it. Volunteer departure. When a person has been offered volunteer departure, they must depart within the time given to them unless they try to ask for an extension and the extension has been granted, right? Sometimes in limited circumstances, ICE will extend the date of departure because of reasons, good cause, reasonable cause. They can do that if you ask for that extension. However, you still have to depart within that time. If you do not depart, what is the consequence? The consequence is you will not be able to adjust status within 10 years, and you will be, this volunteer departure order will be categorized as order of removal, and it will become final. So technically you will be order removed. It's going to be considered as removal order because the person failed to depart, as they said. That's why before you ask for volunteer departure, you need to ask yourself questions as, am I really going to leave? Because if you leave, then the bar that is attached to volunteer departure is no longer the bar that is attached to order of removal is not going to be attached to you in terms of if you want to come back later on. Remember, a person who's been order removed, they have a 10 years bar when they're outside of the country, and really they cannot come until the 10 years has passed. Or if they apply for permission they ask for permission to reapply, and discretionary, of course, if it's granted, or if USCIS exercise discretion on their behalf and it's granted, then they can come back. Usually we advise people, if you have a bar of 10 years, you wait at least 5 years to basically try to ask for permission to reapply by using the form 212, because motion to reopen after departure is kind of difficult to be granted because of lack of jurisdiction post motion departures. It's a really complicated area. So the best way to go about it is just really ask for permission to reapply. That's the most common way. It doesn't mean that you can't reopen a case. It just means that it's best to try to ask for permission to reapply. Anyway, so now if a person just asks for volunteer departure, it's been granted, they never ask for extension, or they ask for extension but still fail to depart within that time frame, and they stay, they have a 10 years bar. And what's going to happen later is when you are able to adjust status, maybe after 10 years, you have a child who becomes a U.S. citizen and try to adjust status and to reopen a case, most of the time ICE will not grant that joint motion to reopen. Why? Because you failed to depart. I've seen it a lot of time when a person has a volunteer departure and we're trying to join ICE to reopen a case. Most of the time ICE will say no. As a matter of fact, 2 weeks ago, I have volunteer departure cases, especially the fact that they went to USCIS. It just looks like you're trying to go behind their back to USCIS and see if USCIS will give you a green card, which you just don't do it to, because it's gonna just upset them. Just try first to ask them to join. If they don't agree, then you can just file a motion to sponte with the court and see if the judge will agree with you. So that's why it's better not to ask for volunteer departure if you know you're not gonna go, or if you just did it by mistake and failed to depart, it's just better not to file I-485 with USCIS. Just try to, because anyway it's gonna get denied, and the moment it gets denied, it just upsets ICE. Sometimes ICE will just not agree with you to join the motion, because you first of all went to USCIS prior to coming to them, and the fact that you failed to depart. It's very challenging when a person has a volunteer departure and try to join ICE. People who have been able to do it are TPS holders, because there was a lawsuit, and finally they got into an agreement with USCIS, and that's why ICE most likely joined the motion. But some people are still having a hard time, and we are still to try to find ways to basically help them file motions sua sponte. And if you refer back to my other video about what exactly to do in removal proceedings to avoid all those things, is to, if the case is weak, just take a dismissal or ask for it. And especially if administrative closure is possible, ask for administrative closure. That way you have, first of all, retained the right to work permit, and you have a best way to adjust when you're eligible to adjust. Let's say your child turned 21, depending by the way in which you enter the United States, they can reopen the case and ask you to recalendar the case and ask the court to terminate removal so that you can adjust status. That's the point of having a good guidance in terms of, should I fight for my asylum case? Should I fight for cancellation of removal? Or should I just wait, administrative close the case, or take a dismissal? That way, in 4 years, I'll be able to adjust status. Because look at it, 4 years, it's gonna pass no matter what. But if you have been ordered removed, once the 4 years passes, it's really not that easy to come back and try to reopen the case. Out of 10 cases, maybe only 2 cases get the chance to get reopened. Yeah, if you have a weak case, take a dismissal or administratively close it if possible, because administrative closure too has its own requirements. But dismissal, once ICE offers it, it's because they're seeing your case is weak, and they're not gonna grant anything. They're gonna oppose it. Then you're gonna file for appeal and end up with the same decision of the immigration judge. And then later on try to reopen the case, my friend, not easy. Some people, their reasoning is that, well, I want to keep my work permit, that's why I'm doing this. But look at it, you might keep the work permit for 4 years, right? And then end up with the same decision by the immigration judge at the BIA level. And by the time the work permit will be expired, then now the child who was 17 has turned 21. Even if they they file for you the form I-130, how are you gonna adjust status? You have to come beg them again and hope, really hope, that they give you that possibility to join your motion to reopen. I am so glad that we are able to do it for certain people, but disappointed too at the same time that we are not able to do it for certain individuals just because they didn't get the good advice from the beginning. So if you need a consultation with me, please, don't hesitate. Schedule it by using the consultation link in the description box below. Until next time, bye-bye. I am doing again series of adjustment of status video to be posted on TikTok, YouTube, probably on Instagram as well, or Facebook. Again, please share, please like. We're trying to help as much as we can. Until next time, bye-bye.